What I'm going to talk about here is one of the more absurd and extreme lies, and they are lies because the people who spout them should and do know better. People who aren't legally trained who fall for them, I have nothing but sympathy and compassion. But if you believe this, you have been taken around the houses. What am I talking about? I'm talking about this notion that membership with the European Union was essential, if not critical, for the protection and maintenance and furthering of workers' rights within the UK and consumer rights as well, product safety. This is just, I mean, I've heard there are two main problems. The first one is that there's a genuine belief that there was no workers' rights in the UK prior to 1973, and that all workers' rights emanate from EU regulation, directive, and judgment of the European Court of Justice, and that leaving the EU immediately vaporizes all of these and means that workers' rights are now a defunct concept, as well as product safety rights, safety legislation as well. This is utter nonsense. Parliament, through various governments, has been legislating for to put statutory obligations on employers to deal with things like workplace safety, not pregnancy. Well, rights to breaks and holiday paid vacations and sickness leave and things like that. We've been doing that since something like the middle 19th century. It's the same with product safety as well. Some of the main legislation under employment law, things like the Employee Rights Act 1996, the Equalities Act 2010, these are nothing to do with the European Union. And countless other regulations created by the relevant minister through secondary legislation. We don't need Parliament. We don't need the European Union to make our own laws. Yes, the EU has passed directives and regulations that mandate things like the Working Time Directive and various bits of health and safety and things of that nature. But again, they were largely useless because we had very similar concepts in the UK anyway. And the other thing you have to understand is that the UK has been and is generating its own form of employment protection for hundreds of years through things like contract law and tort law. So with contract law, the contract is between the employer and the employee. There are certain rules within contract law which control the employer as the more powerful party and benefit the employee as the weaker party. Things like the rule against duress and economic duress, and some things like intention to create illegal relations and things like that. And in tort law, for example, tort is the law pertaining to the breach of an alleged civil wrong. The greatest, probably one of the most profound cases in British history. So profound, I can't remember what it's called. I can't believe it. I've gone blank. What's it called? Shoot. I've totally checked out. Where is it? Okay, I'll come back to it. The hell was it called? The case about the poisoned beer, which basically created the whole tort of negligence. Prior to that, if I made a defective product and sold it to you, we have a contract, and you get injured by it, you would sue me under contract because I provided you with a device or food or whatever that breached the implied terms of the contract. You didn't pay me to get injured. What that case did, Stevenson, I think it was Stevenson said, is that a friend bought a beer for another friend, so she had the contract with the beer producer and then gave it to her friend, who drank it, got sick because there was some semi-decomposed snail in the bottom. The defendant said the case should be thrown out because there was no contract between the person who was suing. There was a contract between the person who bought the beer and the beer maker, but no contract between the third party. They said that it's a rule called the privity of contract. A person only who has privity to the contract can sue for breach of contract or have the contract upheld or such. What the court said, no, that's a fallacy. You do have a duty to this woman, irregardless if you had a contract or not, because you have a duty not to produce poisonous drinks. And the insurance industry was born. It didn't. I don't think that case even got to a hearing. It was. I think it was ruled on like a bench hearing or something. But the implications of that are. But the point is that the common law or the case law. I use the word case law because it makes it a bit easier, doesn't it? Case law has been generating protections for consumers and employees for hundreds of years because people have been taking their grievances and their wrongs to court and having their claims recognised. So what happened in the late 19th century and all the way through the 20th century is that these cases were happening and workers and customers were winning. That created legal uncertainty because of the nebulous nature of judgments, and because judgments can get overruled by later courts. Parliament was lobbied to codify these new rules into statute for the benefit of business owners, because they didn't know if they were going to get sued or not if they made a product that was sold 10 times down the road to so and so and he cut his finger. And things of that nature. But the idea that we need the European Union to tell us how to take care of employees is nonsense. I think that the trend these days is that employers want to take care of their employees, because if they don't, they get sued. So the idea of this sort of Dickensian robber baron, I think, is long gone. Don't get me wrong, there are corrupt employers out there, but I'm saying it's much cheaper to take care of them and have lower insurance levels and not get sued for millions than it is to run a sweatshop. And we don't need the European Union for that. And also, all EU law is still on the statute books anyway, and most of it is, and it's there until we want to change it or not. So there.